ruined by the cost of the defense, whether they were acquitted or not. When she went to the criminal courts on behalf of her poor clients, Foltz came as an outsider and a newcomer. Thus, she saw the injustices ignored by the regulars, who she said were deadened in feeling by constant contact. Today, we call it case hardened. And we've all known some judges who got that way, and prosecutors. It was not a great mental leap from Foltz's firsthand observations to the idea that the state was responsible for a fair presentation of both sides of the case. She probably first started urging a public defender a few years after she opened her practice, and talked about it in lectures that she gave in the mid-1880s to supplement her income as a lawyer. One of her most popular lectures was titled simply Lawyers, and it was in part a humorous account of her lawsuit against Hastings. She then went on to talk about the profession generally, and especially the inadequacies of appointed counsel and the unfairness of pitting trained prosecutors against shysters, incompetents, or no lawyers at all for the accused. She told her audiences that it would change everything for the criminally accused to be represented by a powerful figure backed by the full resources of the state. At the same time she spoke of justice for the accused, however, Foltz's subtext was equal treatment for women lawyers in the courtroom. Too often, she had found herself on trial along with her clients. The prosecutors reacted harshly to what they saw as the unsporting advantage she had with all male juries. They thought that the jurors would be gentlemen and do what the lady asked. But paradoxically, though they thought she had an unfair advantage, they found it a peculiar humiliation to lose to a woman. Some prosecutors routinely attacked both Foltz and her client, him for his alleged crime and her for doing the dirty, unfeminine work of representing criminals. A prime example of the difficulties she faced as a woman defense lawyer was a case Foltz tried in 1892, in which the prosecutor and police both engaged in serious misconduct. Before his arrest, James Wells had been a successful real estate man with an office near Foltz's in San Francisco, but he was broke and in jail when Foltz defended him on a forgery charge. At trial, she told the jury, "I deplore the fact that the law does not provide for a public defender as well as a public prosecutor. Do you think this poor, innocent man would have applied to a woman to defend him if he had some money to pay a distinguished male member of the bar? I am in this case without pay or the hope of reward." For 5 days, Clara Foltz and the district attorney were locked in heated adversarial combat. She objected to his unfair conduct of the case from opening statement on, and when she lost, Foltz filed a forceful appeal complaining of the prosecutor's misdeeds. She said he misrepresents the facts he expects to prove, he attempts to get improper testimony before the jury in the form of cross-examination questions, he garbles and misstates what is allowed, slanders the prisoner, and browbeats the witnesses. Ultimately, she won on the grounds of prosecutorial misconduct in the California Supreme Court. They reversed Wells's conviction, holding and sounding just like Clara Foltz, if a defendant cannot be fairly convicted, he should not be convicted at all. Wells was a great victory for Foltz, and it was all her own. She tried the case, suffered the loss, wrote the brief on appeal, and ultimately she triumphed. 40 years later, when the United States Supreme Court spoke for the first time about prosecutorial misconduct, it cited Wells as the most apposite precedent in the country. You can imagine how thrilled I was when I discovered that factoid on rereading the famous Supreme Court case of Berger versus United States, the one that says prosecutors, you've all cited it, I know, may strike hard blows but not foul ones. And now you can read it with a special interest, knowing that Clara Foltz's case is cited there. But on the highest point in Clara Foltz's, over the years, her practice and her own running commentary on it through her lawyer's lectures and her interviews and profiles, she continued to urge and refine her conception of the public defender. In the 1890s, she began her organized campaign to make the idea she had been talking about a reality. That's when she drafted a public defender statute, lobbied for its passage, and wrote major law review articles supporting it. But the highest point in Clara Foltz's campaign for a public defender was her speech on the subject at the 1893 World's Fair, which was in Chicago. It was formerly known as the World's Columbian Exposition. In conjunction with the fair, a series of open public meetings, which were called congresses, were held on various subjects. The idea was, it was a big idea, to bring together the leading thinkers in every area of human endeavor, to share and celebrate the achievements of intellect to date. An impressive building, which is now the Art Institute in Chicago, was erected near the fairgrounds to house the congresses, which were a major success. Women fought for participation in these congresses, while the organizers seemed to feel that the women should be satisfied with the first one, which was called the Congress of Representative Women, and was all about women and for women, and that the others should go along in a more normal course. But in the end, the women spoke at 14 of the 17 congresses. They spoke at all but real estate, engineering, and electricity. Nowhere was their participation more contested than at the Congress of Jurisprudence and Law Reform. It was planned to bring together the deepest legal thinkers, distinguished judges, law professors, and practitioners to talk about legal developments in the newly dawning 20th century. Even many of those who counted themselves as supporters of women did not think they were ready for the Congress of Jurisprudence and Law Reform. The women pushing for participation were led by the redoubtable Myra Bradwell, who was editor of the most important legal publication west of the Mississippi, the Chicago Legal News. Shortly after passage of the 14th Amendment, Bradwell had tried to use it for women to establish the right of women to practice law. Basically, her argument was that vocational choice was one of the privileges of citizenship, guaranteed to all, including women, under the newly minted amendment. Though she lost in the U.S. Supreme Court, Myra Bradwell's name became synonymous with women's efforts to be lawyers. In her paper, Bradwell spoke of how ferociously the men battled them to keep women from speaking at the Congress of Jurisprudence and Law Reform. But in the end, 2 women spoke on that prestigious public platform. Clara Foltz and Mary Greene, who was the second woman lawyer in Massachusetts. The two were representative in a sense. Greene, like most women lawyers, was an office attorney, specializing in probate and property matters.